Good morning, friends. Namaskar, Sat Sri Akal, and Adab. This is my 227th video, and it will be once again covering the sale. House sale, because mostly all the judgments which in the recent past for 50 years have been coming are generally been covered under the Grant Act, that no TP Act is applicable within the grants. Now we will today talk of TP Act in exclusivity. Now whether TP Act when made in 1882 was made applicable to Punjab, because I am researching in my more territory, so the British territories the TP Act was made applicable, but in the cantonment it became applicable under the section 287 to all the civil municipalities in Punjab where cantonments were. TP Act's applicability stood. Now let's say we can show the Governor General orders of 1798, which actually gave permission to sale and purchase. So that means sale was happening since then. TP Act came exactly about 90 years later. So we need to understand now in this entire present doing, what is immovable property, either as per the TP Act or the General Clauses Act. Now, do these two acts define correctly what actually is being sold to us as an immovable property through these sale deeds from 1798 till 1882 and from 1882 to date 2024. Now, TP Act was notified on 1st July 1882 and it was extended to the entire British territories except for those states which were Part B states, in specific Bombay, Punjab, Delhi. Till November 1956, the applicability was restricted. So the applicability of 1882 Act was made directly, which were governed by the Governor General order through the Governor or through the Governor General in Council. So this is very important to understand. Now, when the commencement of the TP Act 1882 was being enforced, the territories in India which were under the British rule, excluding Burma, Bombay, Punjab, the then Pepsu and Satluj states, no TP Act was applicable. So now the dates of applicability for Bombay was 1st January 1893, after 11 years. Sindh province, it was 1st January 1915. Burma, it was 22nd December 1924. Similarly, it was notified for Manipur, Pathan, Pipaloda in 1929. After India got independence in 1947, the native states were merged under the jurisdictions and was handed over to the provincial government. Now, this is very important to understand Part B states. Now, these extra provisional jurisdiction act of 1947, it gave an extension and merged the Law Act of 1950, and states under Part B were brought under the same rule. Now, the expression except the territories which comprised of Part B states was substituted with an expression except Part B states. Now, what does this mean? So the change was important for the native states called Part B states, which had already had been a part, because they were native states. They were not independent states, were included in the Republic of India. So this act gradually was to be enacted into them. So Tripura and Vindhya Bharat, now Madhya Pradesh, it was enacted on 16th April 1950. Some people talk to me that Mau was an Holkar state. Kerala Act 2 of 1955 imbibed the TPA Act. Mysore, except Bellary, the Mysore Act 32 of 1951. Rajasthan official notification of 1952. So this is how TPA Act was becoming applicable in various independent states. But it is very amazing to know that the applicability of TPA Act in Punjab. Now what is Punjab has to be understood. Will Satluj state, which were native states, belong into Punjab, or was Punjab outside the Satluj terrain until entire Lahore, which was the Maharaja Ranjit Singh's territory? As per an Supreme Lahore Privy Council judgment of 1955, TPA Act was not applicable in Punjab. So friends, we need to understand then how come TPA Act was being applicable within these cantonments. Let's say in Satluj state we had two cantonments in the Punjab terrain, which was Ambala and what was Firozpur. The other were in the hill states was Sabatu, Dakshai and Kasauli. So how was TPA Act being applicable in these? Under section 54, 107, 123, it was extended through a notification of 6th May 1935 that all municipalities in Punjab, and this was Mahapunjab, na? The bifurcation was not done that. Under the Gazette of the Notification section 241 of the Punjab Municipal Act 1911, as per the Gazette Extraordinary number 27 of 1925, the TPA Act was applicable. So CLA rules or Cantonment Act actually changed from 1924 onward. So section 54 para 2 and 3, 59, 107, 123 were added under the 1885 Act. Now TPA Act's amendments were taking section 2 with retrospective effect of section 54 para 2, 3 and 59, 107 extended under the cantonment section 287, 1924. So this is how these enactments were taking place. Notwithstanding with the foregoing parts of the section 54, para 2, 3, 59 shall not extend or be extended to any district or tract of country from time being excluded from the operations of the Indian Registration Act, Sub Act of 20 of 1920, 9 and Section 2 of 1877 Registration Act upgraded to 1908. So this would mean that TPA Act is not applicable in this part of the state and its territory. Does it mean that all sale deeds which were being done of these bungalows or properties and houses, leases, mortgage, gifts would take place under the Registration Act and not the TPA Act? So this has to be understood. Why? Why were we being subjected to these kind of rules? When from 1793 till 1924, sale deeds were coming under these acts, minus these acts and Governor General orders, then why all of a sudden these sections were being specifically subjected to the Punjab Municipal Act and the Cantonment Act? So we need to understand the TPA Act that before the act in coming, all sales, gifts, leases, mortgage were governed by the principles of equity of certain statutes in form of regulations. See, here he clears, after the coming of the TPA Act, certain pre-existing enactments were saved. Likewise, the Governor General in Council and regulations which were enforced before this act, they were either repealed wholly or partially. So 4 statutes dealing with these under the Act 9 of 1842, the Governor General Council repealed these, and the remaining parts were specified under the Bengal Regulation 1 of 1798 and Bengal Regulation 17 of 1806, which were totally repealed. And similarly, Bombay Regulation 5 of 1827 and various till Punjab Law Act of 18. So now, let's say TP Act's applicability was made very restrictive on us, and in Punjab it was not applicable, but we came under the 2 acts, the Punjab Municipal Act and the General Clauses, or the Cantonment Act 287. Now, so we need to define and we need to understand then what was being sold as the word immovable property in TP Act and General Clauses Act. Is this word immovable property being defined? Most of these sale deeds talk of sale of immovable property. So Section 3 of the TP Act, where it states the interpretation clauses. This act, unless there is something impungent to the subject or context, immovable property does not include standing timber, that is trees, growing crops or grass. Instruments means a non-testimony instrument. In relation to an instrument means and shall be deemed a way to have meant attested by 2 or more witnesses, each of whom has been executant, signs or affix his marks to the instrument, or has seen some other person sign the instrument in the presence of the directions of the executant, or has received from the executant a personal acknowledgement of his signature or mark or the signature or persons, and each of whom has assigned the instruments and executants. But it shall not be necessary that more than one of such witness shall have been present at the time, and no particular form of attestation shall be necessary. Now, what does registered means? Subsection Act 3 of 1951, Part A state or Part C state adoption of laws in various territories to which it has been extended under the Indian Registration Act 1908, law for the time being in force regulating the registration of documents attached to the earth means rooted in the earth, as in case of trees and shrubs, embedded in the earth, as in case of walls or buildings, attached to what is so embedded for a permanent beneficial enjoyment of that to which it is attached. So, now this is the documentation which were being done under the registration attached to earth. So, registration has been defined like this. Now, similarly, action claim. Actionable claim means a claim to any debt other than debt secured by mortgage of immovable property or by hypothecation or pledge of movable property, movable, or to any beneficial interest in immovable property not in the possession, either actual or constructive, of the claimant, which the civil court recognizes as affording grounds for relief, whether such debt or beneficial interest be extinct, accruing, conditional or contingent. So for this now Act 5 of 1930, Section 2, a person is said to have notice of a fact when actually knows that fact, or when but for willful abstention from an inquiry or search which he ought to have made, or gross negligence, he would have known it. So these kind of explanations were then transacted in these sections relating to immovable properties required by law to be and has been effected by a registration document or an instrument. Any person acquiring such property or any part or share or interest in such property shall deem to have notice of such instrument as far the date of registration, or where the property is not at all situated in one sub-district, or where the registered instrument has been registered under subsection 2 of section 30 of the Indian Registration Act 1908. From the earliest dates of registration, instruments and various sub-registers have been filled within these sections. Property which has been acquired, or the property wherein the share of the interest has been acquired. So you have to mention all this, he says, provided that the instrument has been registered and is registration completed in the manner prescribed in the Indian Registration Act's various rules. The instrument or memorandum has been duly entered or filled, as the case may be. Book value section 51. The particulars regarding the transactions to which the instrument relates have been correctly entered as per section 55. Now let's say a person is selling an immovable property or any share or interest in such property, shall deem to have notice of the title, if any, of any person who is at time being in actual possession. So you have to specify, he says, a person shall be deemed to have had notice of any fact in his agent or his agent acquires thereof, whistle acting on his behalf in the course of business to which fact is material. So these many things have been interpreted. So this section finally is trying to interpret that no registration or sale under the immovable property is done by any person without two witnesses, should not be a fraud, and he should not be selling any title which he has not acquired through the various earlier titles which he will mention in the sale deed. Now the main question which is to be interpreted in this entire TP Act is immovable property. It has neither been clearly or completely defined in the TP Act or the Registration Act. It does not speak what is to be included, what is not. If an act and a meaning, and the meaning of any word is not given clear, the meaning of that word can be found in the General Clauses Act 1897. Now, under section 26, what does that act speaks of immovable property? Shall include land, benefits to arise out of land, and things attached to the earth or permanently fastened to anything attached to the earth. That both these acts have not been able to define the expression of immovable correctly. Now, what would it mean when you don't have such definitions coming? So, land would be defined whether under the Constitution or basically what the Britishers started from 1765. Land means surface of earth, including everything upon the surface of land, under the surface of land, and also above the surface of the land. So below the land, above the land, anything on land, so long it is not removed from there, shall be part of the land, and such immovable property, thus solid or mud deposit or water collected in a pit or accumulated in a pond or lake, is immovable property, because the water is part and parcel of the surface of the earth. Water flowing gives an expression, it is immovable property. But that is not true, as it flows on the surface of the earth. Similarly, everything under the earth like coal, gold mine is immovable property. Moreover, not only the things on the land and under the land are immovable property, but the space which is above the land is also a part of land and is an immovable property. Looking closely, we see that space begins from the surface of the land and goes up to sky as it has been placed on the land. Benefits to arise from land which person gets from the land is also immovable property. Any right exercised by on the land and the person makes profit or gains which he retains will automatically attach the immovable property as part and parcel of land. Thus, right of way exercised on the land or a right to use land under lease or tenancy is immovable property. Things attached to earth has been defined separately under section 3 of the TPA Act. 1. Things embedded to the earth which are firmly fixed to the earth and become part of the land. For example, house, building walls, electricity poles are all immovable properties. Wall of the house are not placed on the surface of the earth, but they are deeply dug into the earth, and there the whole structure is fixed and built up is called permanently. Machinery which is embedded to the earth through nuts and bolts will not be called permanent. It is just an installation which is to be treated immovable property. So, two things attached to what is embedded on the earth is permanent, then it would be called immovable property. Doors, windows of the house are attached to walls for permanent enjoyment of the house. 3. Things rooted in the earth, trees, plants, shrubs are deep rooted in the land, are itself called a part of earth. So the general definition under the General Clauses Act 1897 clearly reads, this act and in all central acts, regulations made after the commencement of this act, unless there is anything repugnant in the subject or context. So here he defines British India. It's very important. Shall mean as respects the period before the commencement of Part 3 of the Government of India Act 1935. All territories and places within His Majesty or Her Majesty's dominion which were for the time being governed by His Majesty through the Governor General order or through the Governor or officer subordinate of the Governor General of India, and as respect any period after that and before the date of establishment of the Dominion of India, means all territories from time being comprised within the Governor's provinces and the Chief Commissioner provinces. The British India in Indian law passed or made before the commencement of Part 3, 1935 Act. It shall not include reference to Berar. Now comes, that was British India. Now this is British possession. Now what does possession mean for British? Any part of Her Majesty Dominion exclusive of the United Kingdom and where parts of those dominions are under both a central and the local legislature. All parts under the central legislature shall, for the purpose of definition, deemed to be British possession. Because it was the British government, so any subject in 1935 which was subjected to the matter of land in the central pool, it is British possession. Immovable property shall include benefits which arise from land attached to earth, permanently fastened to anything. Now, the most important definition is local authority. Local authority shall mean a municipality, a committee, district board, body of Port of Commissioners or other authority legal entitled to or entrusted by the Government of India with the control and management of municipal and its funds. So what is the Cantonment Board doing today? It is only managing our lands. It is only looking after the Cantonment Fund. Friends, please understand these definitions. These are very important for your pleadings in court cases. And I request everybody to look into them seriously. Because we were always considered something which I have been saying, that we were old grants, never converted into new grants till 1859, Privy Council order. So this opportunity of resumption by the Governor General or the Board of Revenue Officers diminished after 1859. So these old grants remained old grants because we were paying our revenue lagan as subjected to us. We were supposed to be converted into new grants, which was not done. So, TP Act's applicability, I hope you will understand and make a decision. Thank you. Good day.